Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday night. Where most of us are normally sleeping. We're awake, watching court videos. So, I hope you guys had a good Wednesday. I know a lot of you are going through a lot of it right now. So, hopefully tonight takes you away from that just for an hour or two. Let's start with American Courts doesn't go live. It's all AI recorded. Right, Bill? Hi, Bill. All right, we're going to go to Indiana.
Versus Catherine Strickland, 20D042504 CM837 and 20D042512 CM2464. Defendant appears with counsel Ethan Lay. Could you please raise your right hand to be sworn in for me? Do you swear or affirm any testimony you'll give today will be the truth?
Yes.
Thank you. State your name, please.
Catherine Strickland,
What's your date of birth?
3/22/1980.
Can you still receive mail at 6 Mishawaka?
Okay, then what was her address, Bill? What was her address and her social security number?
Yes.
Okay, it's the address we have on file. Are you aware that you have a hearing in St. Joseph County May 14th at 9 a.m. on some other case?
Yes.
Okay. Your attorney handed me a plea agreement. Do you want to plead guilty today pursuant to this agreement to resolve your cases?
Yes.
All right, for you to plead guilty, I need to ask you a series of questions. Just let me know if I say anything you don't understand. Do you read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you have either a GED or a diploma?
Yes.
The plea agreement and advisement of rights and penalties form both appear to have your signature on the last page. Did you sign both documents?
I just refreshed the YouTube without Bren's help.
Yes.
Did you have enough time to read through and fully and thoroughly understand both documents before court today?
Yes.
Do you understand that by pleading guilty, you're waiving your right to a trial?
Yes.
Do you understand by pleading guilty, you're waiving all of the rights contained in your plea agreement and advisement of rights and penalties form?
Yes.
Your plea agreement calls for you to plead guilty only in one of the cases, theft, a Class A misdemeanor, in the case that ends in CM2464. Do you understand the charge and the possible penalties you're facing in that case?
Yes.
For you to plead guilty, you have to admit to all of the material elements of the offense. So I'm going to ask you as follows. Is it true that on or about August 1st, 2025, here in Elkhart County, state of Indiana, you did knowingly exert unauthorized control over the property of another person to have merchandise of Five Below?
Mhm.
Ma'am, you have to answer out loud. Okay. And did you do so with the intent to deprive Five Below of the value or use of any part of their property?
That was not the intent, but yes.
Well, what did you do?
I offered to return it or pay for it. I was refused either.
Well, did you leave the store with something you didn't pay?
Right, and then I turned around and offered to return and pay for it.
Well, when you took it, you knew you didn't pay for it, right?
That's why I said yes.
So you stole their property, correct?
That's why I said yes.
Don't get an
I
attitude
don't
with
have
me,
an
ma'am.
attitude.
It's not going to work well for you.
I said that wasn't my intent.
Okay, well, I need to ask you some questions. Just don't get an attitude with me.
Okay.
You committed a crime. I have to get a factual basis. You got to answer my questions no matter how uncomfortable it is. When you took their property, did you leave the store without paying for it?
Correct.
Okay, so when you left the store without paying for it, isn't it logical that at the time you left the store knowing that you didn't pay for it, that you had the intent to deprive Five Below of the value of their property?
No, I just had things on my mind and that was nothing.
Okay, so are you telling me that you didn't realize that you didn't pay for the property?
Correct, I had a lot of things on my mind.
Okay, then I can't accept a factual basis. So I'm just going to set the case for trial. I will actually set both cases for trial. Let's see what all I have now. I've added July 9th. Let me see if it works for these two. I have room.
No.
So
They have expensive stuff in Five Below now. You walk into the wrong section and everything you put in your cart is $50, $25, $15.
Ma'am, I'm going to set both of your cases. Before I actually say that, I want to see if there was ever a jury demand. I'm sorry, forgot to check. So 837, there's not, and then 2464.
I need a bow tie.
Well, not necessarily, because it was a transfer, and sometimes transfers from city court are due to a jury trial demand being filed. But that's not the case here. They just transferred it because she had the other case. So, Ms. Strickland, I'm gonna, first of all, does a bench trial for the cases work for both sides for July 9th?
Yes, sir. Yes, sir.
Okay, Ms. Strickland, I'm gonna schedule both of your cases for a bench trial on Thursday, July 9th, 2026 at 8:30 in the morning. Do you understand and acknowledge that your bench trial setting for both cases? If you fail to appear for your bench trial, the trials can go forward in your absence. The court could convict you in your absence and a warrant could be issued for your arrest. Do you understand that?
Yes.
Well, so the defendant acknowledges her bench trials in open court. Do you want me to set a pretrial conference on June 16th?
Yeah, if we can do the June 9th date again, that would be great.
It's an interpreter date and I'm really full.
June 16th works.
I would prefer the 16th.
June 9th already? It was just snowing. It was... People were just shoveling just a couple days ago. Martha, thank you so much. I appreciate it. People were shoveling a couple days ago and they're talking about June.
That was for the city.
Okay, you got to be here on June 16th, 2026 at 8:30 in the morning. Mr. Legg, I'm going to give you back the paperwork. We'll show in the CCS the court was unable to establish a factual basis in the theft case. Stay in contact with your lawyer. Do not drive if you don't have a valid license. I'll see you June 16th at 8:30 and you have a nice day.
Thank you.
Thank you.
Holy Lobster. I like that screen name. You got a good screen name in there. All right, we're going to go to one more court for the rest of the day. GTA. Grand Theft Auto Kid. He's last, I think.
All right, thank you, Your Honor.
Thank you.
I'm gonna put in the order, he's held on no bond.
He's held on the violation case.
Okay.
At 326, he's held on
Thank you.
no bond. That's your in a sentence.
All right,
The magistrate set a bond in 270 $5,000, but it's sort of immaterial because he's
Right.
serving execution.
Yeah.
Thank you.
Morning, Your Honor.
Brain surgeon. Yeah.
Brandon Thomas, Your Honor.
We see him in the courtrooms all the time, in the different courtrooms, but we never get to hear him talk. He's always just sitting on the sidelines. I don't even know what his name is.
Still on the breath. Didn't I tell him to show up before it? Wasn't that the issue last time? He had no way of getting up here, and I think I gave him plenty of time to make arrangements for a ride.
I believe that I was recently, let me double check. I might have
Managed
managed.
to drive up here and get an H&B or on the wheel, allegedly.
He informed me that he had a ride to cancel at the last minute, so he's 90 minutes away.
In Peru,
Yeah.
I'll be 60 minutes away. 31, 4-lane road all the way up.
The way you drive, Judge.
No stop lines either. Huh.
I
Did
could
that
get there in
last
20
night at
minutes.
the gas station there. You're home free. Believe me, I've taken that trip many times. So, what do you suggest we do?
Your Honor, I've asked him to be by his phone. I'm newly appointed on this case. I'm going to set up some Zoom conferences with him so that I'm able to communicate effectively with him without him having to struggle to find rides, but part of the issue, presumably.
Well, that's the same issue I heard last time. So I'm gonna tell you this, I'll call him this time and that's it.
Okay.
He doesn't show up for court, I don't care if he has to walk from Peru. He needs to be here in court. It's a relatively minor, in the scheme of things. We're not dealing with John Doe, but just show up.
Yes, Your Honor.
Everybody else shows up, or they get issued a warrant.
I wonder if everybody didn't individually keep saying hello to everybody else individually instead of just, hey guys.
Hello.
How many chat
Thomas, how come you're not in court?
Chat would have each stream?
Yeah, I had a ride lined up and it canceled on me. I've been trying, it's just a hassle for me to get over here without no license.
Well, sure, it's a hassle for me for you not showing up in court.
I apologize.
Well, if I told your lawyer, Mr. Blatt is here, your contact information, I guess you must.
Yes, Your Honor.
I told your lawyer that we're gonna set this over and, if you don't show up physically in court, I'm just gonna issue a warrant and the sheriff to make sure you get up here.
Yeah, but I don't want that.
Yeah, well, I don't either, but you gotta show up in court.
Yes.
And I think I continued this thing, 20 days, almost 3 weeks to give you an opportunity to show up. Personally, and I remember my words to you, hey, that should give you plenty of time to get a ride.
Want to know why it sucks, Brad? Do you want me to tell you why it sucks? Because you're an employee, not an employer. You have to flip the script, and then it won't suck so bad.
Okay.
So, Mr. Blatt, when do you think you would want to come back on this case?
We could set it for April 20th, Your Honor. That gives them 3 weeks.
Maybe we gotta set it for a little bit longer and I give them 4 weeks, and so just in case that ride falls through.
Well, I'm here every day that following
Oh, that ride's gonna fall
whichever
through,
works for the
Judge.
court.
April 27th, is that
That's
right?
fine.
All right, Mr. Thomas, April 27th, that's 4 weeks from now.
So, what time?
9 a.m., Mr.
It
Thomas.
doesn't matter.
9
You're not
o'clock.
gonna show up. Doesn't matter
April
what
27th
time.
at 9, okay, thank you.
Yes, yeah. Good, anybody else?
Your Honor, it's not on the calendar, but just let the court know.
Who else heard their kids say, yeah, I'm gonna clean my room? Yep, that's what I just heard.
You can raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth to help you.
I swear, Your Honor.
All right. Your lawyer's filed a plea agreement. You need to ask some questions. And the first question you need to ask you, sir, is what is your full legal?
My full name is Nathan Tays West.
How old are you?
I'm 31 years old.
How far did you go to school?
I received an associate's degree.
I take it you mean then.
Yo, Google Translate is gonna get me in trouble. I'm gonna show you. Okay, hopefully, I'm hopeful that most of you saw me type the words sugar mama. That's what I'm hoping most of you saw me type. But Google Translate has been freaking translating lately. I don't know why, but just regular words. And it's not, look, they're not doing a great job. I'm showing you right now. Image there. Coffee. Don't worry about it. Don't worry about why I called this image coffee. Don't worry about it. Where is it? There. This is how Google translated sugar mama. When Chinny comes in, you guys say porcelain. I see you guys type the weirdest stuff. And then I see that little mark beside your name and I thought, oh yeah, Google's doing it to me again. But look at that. Look at how stupid they are. Okay, it's fine. It's fine. I just paused it for that.
In English?
Yes, Your Honor.
I'm gonna go to the last page of this agreement and I see 3 signatures. 2 of them I recognize, that of Mr. Briner, your attorney, that of Jennifer McKinney, the prosecuting attorney, that 3rd signature. So is that your signature?
Yes, Your Honor.
Did you read this agreement before you signed it?
I read it thoroughly.
Okay. You read it thoroughly before you signed it.
Okay. Yes, sir.
Okay. I'm going to ask you a series of questions, make sure you understand what's happening, what you're doing, and enter into this plea agreement freely and voluntarily. During this hearing, if you have any questions, please ask me and stop, and I'll give you a chance to talk to Mr. Briner. You're not a citizen of the United States. Your conviction of the charges filed against you may result less favorable immigration status of deportation according to the kinds of legal advice about this issue if you wish. Is that an issue, Mr. Briner?
No, Your Honor, he's a U.S. citizen.
So you're currently under the care of a doctor, psychiatrist for a condition or under the influence of prescription medication, any other medication, drug or alcohol that would affect your ability to understand what you're doing today.
No, Your Honor.
All right. The first part of the plea states that you, did you put the see him on the board, put it on the see him page?
It's on the,
Is it on? Is that on your document?
it is on
Oh,
the printed sheet.
it's not, okay, the document. All right, but I like it. So, sir, in F6-1, you are going to plead guilty to a level 6 felony. That's count 1. The state will dismiss count 2. The parties agree that any initially executed time shall be kept 12 months. Should he be placed on probation or in community correction for any portion of his sentence, he shall complete a certified best matters intervention program, undergo an IRS, and complete all recommended follow-up. At the request of the victim, the no contact order shall not be continued as part of any sentence. That you acknowledge that the court shall enter a domestic violence determination at the time of sentencing, and the parties are otherwise free to argue at time of sentence. That's your agreement in regard to that F6 clause number, sir. So I want to talk to you about that for a second. That cap of 12 months, I want to make sure we're on the same page. I don't know anything about you. I know what you're pleading guilty to. I don't know what the proper sanction of this offense is, but after listening to you, lawyer and your lawyer at the state and the probation department, I came to the conclusion that community corrections or jail or even prison was the proper sanction for this offense. The most heavy sentence for initially would be 12 months. Now, if I treat it as a felony, I have to treat it as a felony, excuse me. That doesn't mean that I couldn't sentence you up to 30 months. But I'd have to spend at least
30 months. Wait. I lost track, guys. I was looking at chat. Is this the guy who just found a bag of money at the casino and just took it home? And then the police contacted him, so he gave it all back? 30 months in jail?
sounds well, that your understanding as well, attorney.
I understand that now, sir.
Right. You have any questions about that now that you understand that?
No, Your Honor.
Okay. All right, so in the CM clause number.
We don't have a chance with CJ.
That added on late. Mm-hmm. Now, in the 71 D06, 2509 CM 2060, the plea is that you would plead guilty to count 3, leaving the scene of an accident, a Class B misdemeanor. The state shall dismiss counts 1, 2, and 4. Defendant agrees to pay properly documented restitution to the listed victims, and the state shall make no recommendation as to the sentence. Is that your agreement with the state, sir?
Yes, Your Honor.
Yes, sir.
Judge, I heard the court comment that the plea bounds the court to enter the F6 as a felony at the time of sentencing. I don't believe that.
Domestic violence, isn't it?
It is domestic. Yeah.
So, is that wrong?
My mistake. I
Maybe they made a change in the law after the session. I wasn't aware of it. But
My mistake.
it stays as a felony, correct? Okay. So, where was it? So in this regard, I could sentence you, because I'm looking at this plea agreement. And there's a paragraph in your plea that says, I understand I have a right to appeal my sentence. There's an open plea, so the plea on the B misdemeanor is an open plea. And an open plea agreement which leaves the sentence to my discretion. And you waive your right to appeal your sentence under Creek v. Scale. That's a paragraph in your plea. So you're waiving on that B misdemeanor your right to appeal any sentence. So I could sentence to 180 days. You understand?
I understand.
And you couldn't appeal it. You're waiving the right.
I understand that, Your Honor.
The other thing I should tell you in regards to your felony case, I can sentence you up to 30 months. I got suspended down to 12, but you couldn't appeal that either because of that waiver. That suspended portion of your sentence goes up to 30 months. You understand that?
I'm grasping on this, Your Honor.
I'm sorry?
I'm just grasping it now. I understand this.
Okay, I'm just saying that you signed a waiver of the appeal, and I read the transfer denial by the Supreme Court. Whenever there's a sentence, I read it, that I have discretion sentencing you to the maximum, but show it to plea agreement, I'd have to suspend it down if I wanted an execute. So if I thought an execute sentence was appropriate, I'd suspend it down to that 12. But as long as I sentence you within the parameters of a level 6 felony, I'm good. You understand that?
Okay, I understand.
And you can't wait. You can't appeal that. You're waiting. You understand?
Yes, Your Honor.
Any questions about that, sir?
No questions.
Okay. So in the misdemeanor case, let's see. The state would have had to prove, and I can't be pleading guilty to, sir. The state would have had to prove that on or about September 14th, 2025, in St. Joseph County, state of Indiana, that you being the driver of a vehicle, was involved in an accident, involved in a collision with damage to the property of many you did knowingly fail to take reasonable steps to locate, notify the owner of the person in charge of the damaged property or contact law enforcement officer or agents. That's what the state would have to do in regards to your
I was wrong. This is not the casino guy. This is the hit and run guy.
senior felony case. State would have to prove beyond a reasonable doubt, even legally admissible evidence, that on or about December 31st, 2024, state of Indiana, you did knowingly or intentionally touch Amanda Villagrana, is that it?
It's not Villagrana.
A family or household member you would consider in the manner, and that you committed the offense in the presence of the child less than 16 years of age. You know, the child was present and might be able to see or hear the offense. That's what the state would have to prove beyond a reasonable doubt in that case. Since you're admitting guilt, sir, to both of those charges, the state will have to prove the charge, which means no trial, that instead of judgment of conviction we had your consent imposed. Because there's no trial, you're the following trial rights. Speeding public trial for judge and jury, you confront, cross-examine stage witnesses, call witnesses on your own behalf, and for you not to testify. Do you understand your legal rights?
I understand.
Do you have any questions about the rights?
No questions.
You're also giving up the right to appeal your conviction, and you're giving up the right to appeal your sentence as long as they follow the terms of the plea agreement. So understand that.
Yes, Your Honor.
Sentencing range for level 6 felonies, you start out with an advisory sentence of a year, which would be added a year and a half for aggravating circumstances. Usually the biggest aggravated is criminal history, although there's other aggravators as well. 6 months can be subtracted for mitigating circumstances. Usually the biggest mitigator is aggravated history, although there's other mitigators as well. And you'd be fined up $10,000. Because this is a domestic battery charge, sir, I can't treat it as a misdemeanor. Normally would be able to do that, but I can't in this case. It has to be treated as a felon. Yeah.
Understood, Your Honor.
The Class B misdemeanor has a range of sentence from 0 days up to 180 days in jail and a fine of $1,000.
Pretty sure it's 1,000.
Yes, $1,000. And I think those sentences have to be consecutive, do they not, Mr. Brenner? They have to be consecutive.
Yes, they are, Your Honor.
So worst case scenario for you, sir, is 18 months in jail or prison or community correction initially. Wow.
I understand now.
Okay. Or you could be on probation, worst case scenario, for 36 months, 3 years, you understand?
Understood.
Any questions about that?
No questions, Your Honor.
Okay. Other than these 2 cases we're dealing with, were you out on probation, parole, bond without something, any other offense when this offense occurred?
Yes, Your Honor.
Okay, what other case were you out on bond on?
Well, case.
Other than the 2 cases we're dealing with,
I just received a ticket. Is that something?
then what kind of ticket did you get?
So I received a no ops ticket.
No absent possession?
Operating without my ID on me.
Okay. No.
I don't know. It was in Niles. I don't know.
Oh, Niles?
Yeah.
Sounds like an infraction, but I don't know. It could be a felony or a misdemeanor in Michigan. I don't know. I'm not versed in Michigan law, but I will tell you that whatever sentence I would impose on these 2 cases would have to be consecutive. If that's a case that's a sort of offense that's punishable by jail, it's not here in the state of Indiana if you don't have any operating possession. That sentence would have to be consecutive to the 2 sentences here, if you understand that.
Yes, Your Honor.
Okay. Would he be eligible for community correction, Mr. Brown?
Yes, Your Honor.
So if you have any guns, so you have to submit the DNA swab, you understand that?
Absolutely, Your Honor.
But so understand that there's going to be a notification of this charge going down to the BMV, that you have the ability to operate a vehicle now or in the future. And on top of that, because this is the domestic violence battery, there's 2 other things you need to be made aware of. One is that your ability to own firearms is over. It's over for the rest of your life. So you could petition the court, state court, the state court to reinstate your ability to possess a firearm 5 years down the road. It's still a federal offense. Be able to possess a firearm. We doubt very highly the federal government, since it's a separate jurisdiction, to recognize this court's order allowing you to possess a firearm. So unless there's a change in the law at the federal level, your ability to own a handgun, rifle, shotgun, that means for target practice or hunting, none of those things, you can't possess any of those items in the state.
I understand.
And I will send notification down to the Indiana State Police to inform them that you're one of the people who cannot possess a firearm.
Yes, sir.
Okay. The other thing you need to be made aware of, it may have an impact on me.
It sounds like there was some domestic violence in the home. He left after he did what he did and then crashed into another car.
Yeah. Usually comes up in cases of a visitation to a divorce or fraternity. But because of this conviction, your ability to exercise any sort of visitation with your children, minor children, could be impacted. I'm not saying it would be, but it could be, to understand that.
In the case of a divorce,
well, usually it comes up in cases of divorce or paternity.
Okay, I understand that.
All right, any questions about that, sir? Having gone through the rights of waiving possible punishment you face, and you still want to plead guilty.
Yes, Your Honor.
Has anyone forced or threatened you to plead?
No.
Have you made promises to the state, or the state made any promises to you not contained in the plea agreement?
No.
Let's see, other than the terms in your plea agreement, were you guaranteed what your sentence would be?
No, Your Honor.
Okay, I want you to understand, I'm not bound by this agreement. If I accept it, I'll be bound by its terms, which means I can't in future reduce or suspend and impose a sentence unauthorized by agreement without the state's permission. If I reject the plea, you treat as though I resisted. Are you happy with your lawyer, sir?
Yes, Your Honor.
Do you still want to plead?
Yes.
Facturation. Let's do the felony first, Mr. Bryan, and then you can control those.
Thank you, Your Honor. Mr. West, on or about December 31st, 2024, did you knowingly touch Amanda Villagrana in a rudeness or angry manner?
Yes, sir.
And Amanda is your wife, is that correct? So you were married back on that date?
Yes, sir.
And when this happened, there was a child less than 16 years of age who was present. You knew the child was present. The child could possibly see or hear what was happening. Is that correct?
Who was present? I can't say that I knew he was present because I was in an altered state of mind.
Oh, okay. Well, how were you in an altered state of mind, sir?
So I was intoxicated.
Okay, well, you didn't understand. I'm sure Mr. Bryan has explained to you that voluntary intoxication, unless somebody spoke to alcohol, you didn't know, is not a defense to the crime.
Okay, I don't think it as a defense. I was just.
Well, you just told Mr. Bryan you didn't know what you were doing, and there's got to be what we call the mens rea, the criminal intent plus
They're all lawyers on the left.
the act, fine, make it a crime. You don't have the mens rea, you didn't intend to hurt anybody or affect anybody, then you're not guilty of the crime.
Your Honor, I believe I must have known at the moment. It's just afterwards having no recollection of it. It's hard for me to say, but I believe I must have been aware of what I was doing.
Well, okay. So, sir, the affidavit in support of probable cause is that the St. Joseph County Police Department dispatched to your address in St. Joseph County. And then when they got there, they talked to Amanda, and she stated that she had an issue with it. And that she said earlier that morning, her daughter had found you passed out inside by the front door. And she stated you had a drug problem because they found some pills across the kitchen counter. Amanda stated an argument about the pills ensued, and during which you got upset and attempted to yank her wedding ring off her finger. You did this while you were holding their 15-month-old child, CW. And then Amanda attempted to call 911. You took the phone from her and attempted to throw it over the roof. And then you were left to, Amanda was left to go to the neighbor's house and dial 911. When they spoke to you, you stated much the same. You were cooperating with what Amanda had said. And talked about how the argument started. And, well, you denied you had any physical contact, but you didn't make you through the phone to prevent it from filing a, quote, false report. So, sir, you're either guilty of the offense or you're not. That's what the probable cause affidavit.
I believe I'm guilty of the offense.
Okay, and so you wouldn't dispute what Amanda is saying, what she said in the probable cause affidavit. That you grabbed her because you were angry and you attempted to yank her wedding ring off.
That is true.
And you would agree that that would be a rude incident or angry touching.
Yes, that was uncalled for.
And at the time you did it, you knew you was doing it.
I believe so, Your Honor.
Well, you either did or you didn't.
Yes, sir.
So you know what you were doing at the time.
Yes, sir.
And you don't dispute the fact that when this was happening, your 15-month-old child was there, and she was holding, Amanda was holding that 15-month-old child.
Yes, Your Honor.
You wouldn't dispute that either,
I don't
correct?
dispute that, Your Honor.
And so if we went to trial, all of those facts would come out, and you would agree that more than likely the jury find you guilty beyond a reasonable doubt of that particular charge.
Right.
True?
True. Yes, Your Honor.
Dave?
Nothing else on that, Your Honor.
So let's see if we can go to the misdemeanor now.
Thank you, Your Honor. Mr. Westpac, on September 14, 2025, you were driving a vehicle here in St. Joseph County. You were involved in an accident that caused some property damage. Is that correct? Yes, sir. And you did knowingly fail to take reasonable steps to locate or notify the owner of the property that was damaged. Is that right? That's correct. Okay, so basically, you hit the vehicle and then you just left. Is that correct? Correct. I think that's factually so.
Sure.
I'm so sorry.
So when you plead guilty, you give up any defenses you might have had. You understand that?
Yes, I understand.
You're admitting to the crimes of domestic battery and leaving the scene of an accident, because that's what you want to do.
I agree, Your Honor.
Okay. Or finds the defendant understands his rights, charges his spouse with penalties, entered into the plea freely and voluntarily, provided a factual basis for not condition of the defendant's plea. So you have a right to be sentenced within 30 days. You're going to waive that, Mr. Griner?
Yes, Your Honor.
How about May 4th? You gotta be here anyway, right? You gotta about set that.
May 4th should be fine.
All right. You want a community corrections evaluation, Mr. Griner?
Yes, please, Your Honor.
So I'm going to order St. Joseph County Community Corrections evaluation, sir. And you need to go up and the pre-sentence report. You need to go up to the probation department and check in with them. On the misdemeanor list, just get a credit time.
Okay.
You need to go up to the probation department, Fort Florida County City building. You have to go out of this building and around and through the public entrance. Go up there and check in with them so they can start working on your pre-sentence report. I'll see you May 4th at 9 o'clock.
May 4th at 9 a.m., sir.
Yep. Okay.
Thank you, Your Honor.
Yep.
Thanks, Your Honor.
Yep.
I can approach.
Please.
Yes.
Hey, sir, before you sit down, raise your right hand for me, please. You swear to tell the truth, the whole truth, nothing but the truth shall help you?
Yes, sir.
All right, sir, have a seat. All right, hey, your lawyers filed a plea agreement. I need to ask you some questions, sir. And the first question is, what is your full legal name?
Haywood.
How old are you, sir?
23.
I'm sorry?
23.
How far did you go to school?
High school, graduated high school.
Okay. I take it you read and understand English?
Yes, sir.
I go to the last page of your plea agreement, second to the last page of your plea agreement, and I see two signatures. One is by Mr. Stiglitz, and on the back page I see your lawyer's signature, Mr. Stefano, but that other signature there next to Mr. Stiglitz's signature, is that your signature, sir?
Yes, sir.
Did you read this agreement before you signed it?
Yes, sir.
I'm going to ask you a series of questions to make sure you understand what's happening, what you're doing, and you're entering into this agreement freely and voluntarily. During this hearing, if you have any questions, please ask me to stop and I will give you a chance to talk to Mr. Fino. If you're not a citizen of the United States, you're convicted of the charges filed against you may result in favorable immigration status deportation, or to give you time to take legal advice about this issue if you wish. Is that an issue in this case?
Yeah.
So you're currently to care with doctor, psychiatrist, or under the influence of prescription medication, any other medication, drug, or alcohol that would affect your ability to understand what you're doing today.
No.
All right. The first part of the plea states that you will plead guilty to count 1 theft, a level 6 felony. There shall be a cap of 12 months in any initially ordered executed sentence. You agree to pay all properly documented restitution. The amount of restitution shall be determined at sentencing. You're to have no contact with David Davidson. The state consents to future misdemeanor treatment, and the parties are otherwise free to argue. Is that your agreement with the state, sir?
Yes, sir.
So I want to talk to you about this 12-month cap. I don't know anything about you. I know you're pleading.
If your last name is Davidson, why would you name your child David? Why? Come on.
Guilty to it. After listening to you, your lawyer, the state, and the probation department, I came to the conclusion that the proper sanction for this offense was community corrections or jail, or even prison. This figure tells me the most I could sentence you to would be,
As long as he's getting out of the house, I don't care what he's wearing. Just get out.
12 months executed. That doesn't mean I couldn't sentence you up to 30 months, but I'd have to suspend at least down to that 12. Is that your understanding as well?
Yes, sir.
Any questions about that?
No.
And I should also add, sir, that because of that, there's a paragraph here in your plea agreement that if I sentenced you to 30 months and suspended it down to that 12, you couldn't appeal it. Are you waiving your opportunity to appeal the sentence? You understand that?
Yes.
Do you have any questions about that?
No, sir.
Had you gone to trial and charged with pleading guilty to, the state would have had to prove beyond a reasonable doubt using legally admissible evidence on or about September 2025, in Central United States, Indiana. You did not exert control of the property of David Davidson with the intent to deprive David Davidson of any part of the use of the value of the property. That property having a value of at least $750, but less than $50,000. That's what the state would have to prove beyond the reason.
That stinks. They didn't tell us how much. This is the case where he found a bag of money at a casino and kept it. They didn't tell us how much it was.
Without, since you're admitting to the state won't have to prove the charge, which means no trial, that instead of judgment or conviction, we enter sentence imposed. And because there's no trial, given the following trial rights: speedy public trial for a judge or jury to confront cross-examine state witnesses, call witnesses on your own behalf, for you not to testify. Do you understand you're given those rights, sir?
Yes.
Do you have any questions about those rights?
No.
You're also given up the right to appeal your conviction, and you're given up the right to appeal your sentence, as long as I follow the terms of your plea agreement and I sentence you within the parameters of the sentencing scheme for level that level 6 felony. Do you understand that?
Yes.
Okay. Sentencing range for level 6 felonies, you start with a riser sentence of a year, which could be added a year and a half for aggravating circumstances. Usually, the biggest aggravators are criminal history, although there's other aggravating. Well, 6 months can be subtracted for mitigating circumstances. Usually, the biggest mitigator is black criminal history, although there's other mitigators as well. And you can be fined up to $10,000. If I think it's appropriate time of sentencing, I treat this case as a Class A misdemeanor, in which case the range of sentences would be 0 days in jail up to 365 days in jail, and a fine of up to $5,000. Now, if I treat this as a felony initially at sentencing, that doesn't end the discussion because the state says, hey, we agree to future misdemeanor treatment. You agree to future misdemeanor treatment as long as you do everything on probation, correct?
Yes.
Any questions about that, sir?
No.
All right. Were you out on probation, parole, bond, or without sentence on any other case in this offense occurred?
No.
Would he be eligible for community corrections? Yes,
Yes, Your Honor.
Sir, if I treat this as a felony, you'd have to submit to a DNA swab. You understand that? If I read felony sentence. Have you gone through the right to, is that a yes? You understand that, sir?
Yes.
Okay. Have you gone through the right to waiving possible punishment for patient you still want to plead? Has anyone forced or threatened you to plead?
No.
Have you made promises to the state, or the state made promises to you not contained in the plea agreement?
No.
Of course not. Bound by this agreement, if I accept it, I'll be bound by its terms, which means I can in the future reduce or suspend and impose a sentence unauthorized by the agreement without the state's permission. If I reject the plea, be treated as if it never existed. Other than the terms of your plea agreement, sir, you guaranteed what your sentence would be?
No.
Are you happy with your lawyer, Ms. Cristofino?
Yes.
Do you still want to plead guilty?
Yes.
Factual basis, ma'am.
Thank you, Your Honor. Mr. Haywood, on September 20th, 2025, you were here in St. Joseph County, correct? Specifically, you were at Four Winds Casino, right?
Yeah.
And on that date and in that place, you knowingly exerted unauthorized control over some cash belonging to David Davidson, correct?
Yes.
Wasn't your cash and you did not have permission to take it, correct?
Right.
And you would agree that the value of the cash that you took exceeded $750, correct?
Correct.
Ultimately, though, you did return the cash, correct?
Correct.
Nothing further.
Okay,
Nothing else from.
So when you plead guilty to any offenses you might have, you understand that?
Yeah.
Are you admitting to the crime of theft, a level 6 felony, because that's what you want to do?
Yes.
Okay, court finds the defendant understands his rights, charges, possible penalties, and in be free and voluntarily, provided the fact based for not condition accept defendant's plea. Yeah, we talked about $10,000 in loss, or
Judge, the $10,000 I can confirm was returned. I don't think there's additional restitution to request. I am prepared to proceed to some kind of orders.
because I was looking at the affidavit, claiming $20,000, but it was only 10.
All we've been able to release that.
Okay, all right. And that was returned.
Yes.
All right. You ready to proceed today?
Yes, Your Honor.
You know, I paused it. I do that. But are you guys not seeing the video? Unfroze.
What kind of history did you, what kind of history you have, sir?
Oh,
None?
oh, that must be.
Well, tell me what, not much, tell me.
They're resisting,
Okay?
conversion when I was little or younger.
Well, how younger? Because you're only what, 22?
2021. 2021 conversion.
Okay.
That's it.
That's it.
Do you work?
Yes.
Where you work?
Delivery. I do solo contract.
You do what?
Solo contract and independent contract, whatever you want.
You're an independent contractor? And what do you do for them?
Delivery.
Okay. You drive a van around and deliver packages?
Yeah.
Are you married? You have any kids?
I got kids. So
How many?
One.
You supporting that child?
Yes, sir.
That child live with you?
50-50 half and half.
Okay. How old is the child?
She gets time one.
Okay. All right. You want to tell me?
But she's got 6 days in custody on this, I believe.
Yes, 9. So
9 days. This criminal history is fairly minimal. This was a situation where there was a bag of cash left at the casino, unattended. Mr. Haywood found it, took it. The police got involved. He gave it back. I would ask the court to consider treating this as a misdemeanor up front. He has no prior felonies, 2 prior misdemeanors. So I would ask the court to consider a time served plea to give him a misdemeanor.
Judge, I'm making the same recommendation. 9 days is my calculus. His prior conversion was resolved with crucial conversion, so we effectively had the case dismissed.
That's okay.
Some concern that I don't think it's a proper consideration to send some here. You return the cash as far as you can tell.
and gave us no reasons.
So, Mr. Haywood, how long did you have that cash before you returned it? When did the police reach out to you?
Returned it on Friday,
When did you get it?
this weekend.
I'm sorry?
Might have been Saturday or Sunday, it was something on the
So
weekend.
Saturday, Sunday, and then that following Friday, you returned the money?
Yeah,
Didn't spend any of it?
no, sir.
Good way before you sitting here talking to me, wondering whether you should go to jail or then just turn it in, don't you think?
Yes, sir.
Did you post a bond in this case, sir?
Yeah,
How much did you post?
500.
500.
Okay. It's a PD case?
Yes.
All right, sir. The sentence will be 18 days in the county jail. You've served your time. You'll pay, there'll be $189 plus $200 the PD fee. Remainder will go to fine. You're not getting any of the $500 back. That's the cost of doing business. Hey, it seems like you're working. You seem like a pretty decent guy. I don't know why. You know, it's just something that could have avoided just by simply turning in the money. I hope I don't see you again, sir.
This year.
Yes, good luck to you.
Okay, this next kid coming up, I think, if we see him walk towards,
Jason Dickerson?
is a 17-year-old.
All right, so for sentencing today, sir,
Yes, Your Honor.
are we, you ready to go forward?
Yes, sir.
Any changes or corrections that need to be made to the pre-sentence report?
You know, there are two on the cover page. Mr. Mason does not have a license. It
That
says
changes
valid.
everything.
I know.
We continue the sentencing because of that.
I think we're okay. The only other thing, and I just want to make a record on this, you know, as I'm looking at page 6, at his juvenile history, and as probation has it indicated, they're showing a dismissal of count 1 from JD 243. That was the dangerous possession of a firearm.
Mm-hmm.
That's the adjudication which elevated this to a level 5.
Mm-hmm.
I double checked with the clerk in the juvenile court, and it is indeed a conviction. In the juvenile record, I think count 1 and count 2 were sort of listed differently, but that's incorrect. It's actually, there was a sentence on, there was an adjudication for count 1, and I just wanted to make that point so that it's clear.
Okay.
That's all. Beyond that, Mr. Mason comes before the court, 17 years old. He'll be 18 next week. His mother passed away in August. His aunt has been his guardian since then. He would eventually, when he is released, he would reside with his aunt. He's had 83 days. He's been in custody on this case. He's used that well. He's qualified to earn his diploma.
Wait, does that mean that his mom passed away while he was locked up?
And if possible, depending on what happens, he's been approved to walk for graduation on May 14th at Washington High School. There's been no issues or conduct problems at the Juvenile Justice Center based on my knowledge. He continues to take some college and vocational classes while at the Juvenile Justice Center. He had part-time employment as a juvenile. He's in good physical health, fair mental health, though he's had some anxiety and depression issues.
Just for a second.
Yeah.
I read the letters from, I think, tutors at the Meekest.
Yeah.
But if I can interrupt you for just a second.
Yeah.
But I read the probable cause affidavit. I'm struggling, sir.
It is. I
You
get it.
know, I mean, you could have been in a gas station getting gas, just minding your own damn business, and you got some idiot, 2 idiots, I guess, right?
Yes.
Firing guns at each other. So that's troubling. I don't think he's doing very well now, but he's looking at doing substantial time. I think it's the cap on 3 years.
There is.
Prison's not a good place for somebody who's 18 years old. So if he's doing all these great things, what the hell was the thought process with the guns? Getting in a shootout, like said to somebody this morning, it's like you were in a video game.
Yeah,
There was no thought given to it. It's like, oh yeah, there's no consequences. We can just pull out a gun, start firing at anybody in a freaking gas station, and that's okay. So I appreciate all the good things he's done, but what I find troubling is why would you get to that position? And maybe you can't answer that question, Mr. Jasinski, maybe your client can. But why would you get in a position where you thought, hey, you know what, that's a pretty good idea for me to go into a public gas station and engage in a gunfight with somebody? There's something not right there. Just saying.
I understand that, Judge, and I'll tell you on several occasions, I've had that same conversation with my client. And I can't tell you what was in his mind. I can perhaps just point to some age and some really, or lack of age and maturity in a really bad decision situation. And I have reviewed the probable cause and the videos from
But you know what though? Again, interrupting him.
Yeah.
You know, I get it. Your brain hasn't been developed, but I think if you ask anybody who has children, I have a child, I have two children, roughly around your age, okay? And I would ask, if I asked them, gee, you think it's a good idea to go to a gas station and you have a beef with somebody or an argument with somebody, or maybe you don't, I don't know. Maybe you just thought it was a good idea to go to a gas station and start firing at a public gas station. You think that's a good idea? Both of my kids would say no. And their brains are just as developed as your clients. You're an advocate, I get it. I keep interrupting you, but this really, really troubles me. I'm sorry, so go ahead.
No, I understand the concern, Judge. He is young. I know that cuts both ways. You know, he does have a juvenile history, obviously. I think he's done well.
I'm guessing, and I could be wrong, but I'm guessing Judge Sanford was not ever a public defender. I'm guessing he was probably a prosecutor. What do you think?
On supervision, and I think that's what he needs. Turning 18, I candidly don't want him. I mean, I want to save community as well. I do. I live in this community as well. But, you know, I am an advocate, that's true, but I don't know Cavell well. We've met several times. I don't want to see him at the DOC.
We should send him a t-shirt. My kids are better than yours. Court vibes.
Just because I think, I don't, does it prohibit conduct for a period of time? It does. There's no doubt about it. But at 18, you know, he's going to have this permanent felony conviction essentially on his record. It's a hell of a dent. 3 months, I guess, maybe in the grand scheme of things isn't a long time. Probably is when you're 17 going on 18. Essentially, I'm asking the court to adopt the recommendation of the probation department.
All right. Again.
Bill, Bill, if you're still around, can you print up a "My Kids Are Better Than Your Kids" little trophy with your 3D printer? Actually, you know what would be really the chef's kiss? Get one of your drones to fly overhead of them, like going to school, take a picture, put it on the trophy. Nothing could go wrong with this idea. Nothing at all. No, my kids are no better than nobody else's. That's for damn sure. I know this because I live with them. It's Anthony's night for dinner, and he made frozen pizza. That's why my camera was off, because I was eating my frozen pizza. It was delicious. It actually was delicious. It slapped. But I was pretty damn hungry. But he did good. He provided dinner for all of us tonight. Here's dinner. We don't have to think about it. It doesn't matter. It was so good. So yeah, my kids are better than the judge's kids, because my kids cooked me dinner tonight. You think when he gets home, he's going to have dinner waiting for him by one of his kids? Josh, did your kids cook you dinner tonight? Did little Josh cook you dinner? All right, show me who else had kids that cooked them food tonight or bought them food. Either way, either or. I don't care. Come on. Uh-huh. My cats are worse than anybody. Yeah, you feel me? You feel me? You feel me? My cats are a pain in the tush. They're, the only time I can get affection from them is if I don't feed them on time, and then they over affectionate me. They just, and I think this one cat, Lafayette, is really trying to kill me. No, the kids. We're talking about kids. Yeah, your friends are better than my friends, Kelly, because my friends don't ever take me out. Your card is cooking dinner. That would have been some feat if you get home from the track meet and little Josh says, "Go sit down. It'll be ready in 20 minutes. It doesn't even matter what it is. It does not matter what it is. Unless it's beets. Then that's not okay. If they give you beets. Yeah, but Eileen, imagine if Cedar could just provide you the food for once. Which if you let the cat outside, they might bring home a bird or a mouse. So that's their way of doing it. My dog would never bring home dinner for me. Nope. My dog demands food. My cats demand food. Normally my kids demand food. But tonight, Anthony was like, "Hey, I got you. I'll be ready in a minute." And he was, and it was delicious. I ate half of a pizza, but the pizza's really this big, so it's okay. I don't know why, but I really want to see Eddie Murphy delirious right now. I don't know why. This whole conversation is, I got some ice cream. I got some ice cream. And you ain't got none. You've never seen Eddie Murphy delirious, which I know that you have. First watch Bill Cosby at the dentist, and then watch Eddie Murphy delirious. And then follow it up with a little Richard Pryor at Sunset Strip. That would, you know what? That's a perfect night. Eat the food your kids made you, and then that. Oh no. See, kids don't know. They don't know. Oh man. They're saying his brain wasn't developed because they're dumb. Kids are dumb at that age. But I think most kids know not to pull out a gun at a gas station and start shooting at everybody. No, they don't. I know none of my kids made good decisions when they were 17. None of them. Not the boy or the girls. So it's no different. I'm pretty sure my son was getting his head stuck in things still at 17. And my daughters, their heads were like in the clouds. They were like always, like they couldn't focus on what was right in front of them. It's like they didn't care about anything that wasn't in their bubble. Whatever their bubble was, that's what they cared about. Alright, Eddie Murphy delirious. You're going to be crying laughing. It's so funny. Alright, I gotta get back to work. We have 12 more minutes left in this stream. I know it's a short stream, guys, but that's what we got. So I might pause it again. Who knows?
Sorry, bro. All right, Steve, what do you want to tell me?
Judge, I'm recommending a 3-year sentence in this case. I acknowledge the defendant's youth as a mitigator, but both I don't want to comment that he's acknowledging responsibility for, and the fact that we have.
How do you not see Beverly Hills Cops, though? I mean, how? You have got to watch that. It's very good. It's high quality TV.
Tried multiple times to intervene with the juvenile system, with probation and monitoring community. I think those aggravators, outweigh mitigators, and why the sentence is appropriate. At this time, I'm not objecting to inserting pushing that sentence on community corrections. What we said was a better starting point for him. I'm looking to juvenile history request because I think juvenile adjudication should carry some weight as part of criminal offenses, but I'm trying to understand what's been tried with Mr. Mason. I see that there were multiple modifications. At ultimate time, he was on juvenile probation. He had issues with compliance through 23 and 24. Notwithstanding successfully completing juvenile probation there, he committed a new offense that became the basis of this felony. He completed again successfully juvenile probation.
Dr. Doolittle was great. What's the one where he was the scientist? Really large scientist, and he drank and he got real thin. Oh, come on. What is it? I think there was a couple of them. Oh, I can't think of what it is. You guys will know. I know somebody's going to know and type it in chat.
I don't think it's making an impact in preventing recidivism in Mr. Mason's case. So high level supervision and probation for he is appropriate, and I think what we see is very important.
Thank you, sir.
The Nutty Professor is so good.
Mason,
that
what do
was
you want
pretty
to tell me?
good.
I just would like to take the time to say I take full responsibility of my wrongful presumed actions filed against me. And the things that I did wasn't nothing that I could say to justify. I hope to be granted the second chance to store the good that's stored within me and go on graduating May 14th.
Well, Mr. Chisinski, I have a couple of restitution orders here. One for $11,908.80. Do you dispute that?
I haven't seen those.
Yeah. It was filed, and I guess it just filed today. Oh, and here's another one here. There's another restitution order too.
Okay,
You want time?
no,
Are you sure?
yeah. I mean, short of, I guess, I've seen video, I know there was damage. I don't have documentation for it, but I'm ready to move forward today.
So you're not objecting to those amounts?
No,
I think everybody's just a little
Mr. Mason,
sleepy.
I had somebody
Today, Jack.
probably about a year ago, and around your age. And, I told that person, I'm going to tell you, that I'm going to give you a break. But if you come through here on a violation of your probation, we won't be talking about home detention or work release. We'll be talking about prison. Now, this individual who was around your age came back, he violated his placement. That put him in community corrections. And he admitted it. And so guess where he's at now? Prison. And he's doing 12 years. And my guess is a prison's not a nice place for him, and it certainly wouldn't be a nice place for you. And going to prison at your age probably would result in you being worse than you are now. Because right now, sir, I don't think you're a very good person. Your teachers seem to think there's some value in you, and that carries a lot of weight with me. But I think somebody who is willing to shoot at other people in a public gas station really has something missing. And I'm sorry you lost your mother, but that doesn't explain your conduct. Especially after going through this a couple of times in juvenile court. You know, a lot of times I see people get sentenced, as young, and you say, oh, look at this history of juvenile, and then you look and see what the sentence was, and you say, okay, I know what the judge was thinking. You want to send somebody to prison because of their age. But if you come back here on a violation of your probation, you'll be telling me that's where you want to go. And that's exactly where you're going to go. And if you think I'm bluffing, try me, because I can guarantee you that's the state can show me by the preponderance of the evidence that you violated your probation. Prison's exactly where you're going. You understand?
Yes, sir.
How are you gonna pay for this restitution, sir? Any game plan there?
Well, I plan on getting a job upon my release at a factory with me turning 18 and stuff, somewhere I get a decent pay and handle the responsibilities that I'll put myself
Do you have
in.
a job lined up at this factory?
No, sir, but my case manager is helping to look towards me getting some helping.
You're gonna have a heck of a lot of restitution to pay. If the math is right, you owe $13,146.30. That's a lot of money.
What a coincidence, sir. I think the other guy who was here before you found a bag with exactly that much money in it. You should just talk to him. You should talk to him. Get that money.
And that's gonna be a term of your probation, restitution, make restitution payments. So the sentence is gonna be 6 years, 6 years suspended. You have 83 days Class B credit. You'll be on probation for 6 years. It's a long time to be on probation, sir. People have a tendency when they get to...
We're hiring journeyman electricians around here right now for like 75, 80 bucks an hour, which is a lot. We don't live in New York City. We don't live in Los Angeles. We don't live in Philadelphia. We're close to Philadelphia, but we don't live in Philadelphia. Lancaster, man, I should have become an electrician. It's shocking that I didn't.
The end of the probationary period, towards the end of the probation period, let things go. And maybe not follow through on things, and that's when they get tripped up, because you're still looking at doing 6 years. The reason I'm setting that is based on your juvenile history and the amount of restitution you have to make, which is a significant amount of money. I'm going to give you time to pay that. You have a criminal recklessness with a weapon in 2020, resisting in 2023, and dangerous weapon possession 2024. It's you. That's why it's a 6-year suspended sentence. I just want to underline this. You may be sick of hearing me saying this to you. Come back, 6 years in prison. You completed any questions, sir?
No, sir.
You have to pay a felony administrative fee of $100, initial fee of $50, and $15 a month thereafter. You're to complete an IRAS assessment based on results of participating treatment program education class related to the service provided by probation or referral to an outside agency. You will not use any controlled substance without a valid prescription or use any illegal substance, nor are you allowed to consume alcohol while you're on probation. That's a long time. You will submit to random drug and alcohol testing, pay for same pursuant to instruction of your probation officer. You understand you're free to submit drug screen when ordered by your probation officer, but submitting a drug drop, which your analysis shows has been diluted or tampered with, will be considered a violation of probation. You report to the probation department in times and manner instructed by the quarterly probation officer. You work faithfully, diligently, seek employment, and or pursue educational training as may apply to you. You will remain in St. Joseph County, Indiana, unless given permission to leave by the court or your probation officer. You are notified your probation officer and change of address in St. Joseph County within 3 working days. You must obtain prior written permission from your probation officer to move your residency outside St. Joseph County. You consent your probation officer to visit your home place, employment, or elsewhere. You waive any and all rights to search procedure where you submit to search your personal property anytime while you're on probation. You waive extradition and be returned to St. Joseph County, Indiana without the formality of an extradition hearing. Violation of any law may be considered a violation of probation. Failure to comply with terms of probation may result in revocation of probation. Imposition of part or all the suspended sentence. Probation may be revoked in some circumstances up to a year after the terms expire. Do you have any questions about your probationary terms, sir?
No, sir.
Needless to say, you may not purchase, use, possess, or control a firearm or other dangerous device. I will let the probation know that if there's a dirty drop, they're going to notify me immediately. There's a dirty drop, you drop dirty, or if you try to do anything in regards to the dilute, tamper with any urine sample given, they're going to notify me immediately. It's one time. You got pretty tight leash, sir.
One hit, 6 years in jail. That's all it's going to take. They're setting him up to fail.
I mean, but if your teacher sees something in you, so I'm willing to give you a chance. By signing your name to these terms and conditions.
I guess not really, because he already failed. The failing already happened. So, I mean, if he messes up, I mean, he's just paying for what he already did. I mean, so, yeah, they're not setting him up for failure. They're giving him a chance. A hard chance, but...
In terms of your probation, we will abide by them, including compliance with rules of and enforcement is by any agency which you refer to, where only the court may modify the terms of my probation. I also understand a civil suit and or petition to revoke probation filed against you for failure to satisfy financial obligations started by the court. Restitution is a term of probation. Is
Okay. Can I have the rest?
yeah, I'll have them just as soon as I sign. You in custody? Is he in custody of the juvenile?
He is.
Sir, they're going to release you, or be released after they process you out, and make a note that the defense waives any argument regarding this issue.
Okay.
So I'll give you until noon tomorrow, sir, to report to probation. Noon tomorrow, 4th Florida County City Building.
When I was 18, I met my future husband. He became my husband after that. But I was 18. I didn't know nothing about nothing. And he said he was a black belt. I don't know if he really was a black belt. I'm gonna go with he was not. But he said he was, okay? And he told me when I was 18, and I believed him because I was 18, and I thought he was right, that because he's a black belt, he had to register his hands. So if he ever got pulled over by the cops, they would look up and they would know he's a black belt, and his hands are lethal weapons. He's not allowed to hit people with them because of his black belt. I believed him. I believe, yeah.
Now you're on probation for a long time, for 6 years, to 30 of your life. So you need to keep that in mind. And I don't think you want to go to prison, and I don't want to send you there. Please don't come back.
Yes, sir.
All right.
Thank you, Judge.
Yeah.
All right, guys, we made it to the end. I know it's slightly shorter than normal streams, but this is what we got today. We got what we got. I'll see you in 6.5 hours. Thank you for coming out. I really appreciate it, guys. I really do. I hope you guys have a great night, and I'll see you again real soon. Bye.
Well, I thought I'd write a song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,